Let's jump right in, everybody. Today, we are running a specialized masterclass focused on one of the absolute trickiest areas of the NPPE. That's the National Professional Practice Examination. We're going to deconstruct a highly specific exam question all about informal advice and professional liability. My goal as your instructor today isn't just to hand you the right answer, but to literally rewire how you look at every single piece of professional communication you send out. So grab a notepad, get focused, and let's get ready to decode the mind of the exam designer.
Okay, really quickly, here is our roadmap for today. We'll look at the scenario and options, dive into core NPPE concepts, break down the legal theory, explain the correct answer, look at some conceptual traps to avoid, and finally wrap up with key terms and a conclusion.
All right, Section 1, the scenario and options. Okay, I want you to read the scenario here really carefully. A consultant provides informal advice by email, marked preliminary and not for reliance. The client relies on it and suffers loss. What issue is decisive? Now, I want you to actually pause for a second and imagine yourself sitting at your desk. It's Friday afternoon. You shoot off a quick email to a client with some preliminary thoughts. Nothing formal, just a brief update before the weekend. You even tag it with a little disclaimer just to cover your bases. But then weeks later, you find out they actually acted on that quick email, lost a substantial amount of money, and now they're pointing the finger at you.
So what's super interesting here is how that specific phrase, preliminary and not for reliance, creates the absolute core legal tension in our scenario today. You tried to build a fence around your advice, right? But the client jumped the fence anyway. The exam essentially wants to know, what happens now? Does your little phrase actually protect you, or does the client's reliance totally expose you?
To figure this out, let's look at the 4 multiple-choice options provided by the examiners. Option A suggests the decisive issue is whether disclaimers automatically negate duties of care. Option B asks whether reasonable reliance was foreseeable, notwithstanding the informal context. Option C focuses on whether emails constitute contractual representations, and Option D questions whether the advice was gratuitous. Keep these in the back of your mind because we are going to diagnose every single one of them.
Moving right along to Section 2, core NPPE concepts.
So this question is a classic test of your knowledge of civil liability, specifically under the huge umbrella of tort law. In really simple terms, tort law is the area of law concerned with civil wrongs. Basically, when someone's negligent actions, or in this case negligent words, cause financial loss or harm to someone else. And the exact subtopic we're dealing with right here is called negligent misrepresentation. When we talk about negligent misrepresentation, we're really talking about the sheer power and honestly the danger of your professional words. The exam is testing if you truly grasp your professional duty of care when you're communicating information.
All right, Section 3, the legal theory.
As a working professional, you're constantly going to provide both formal and informal advice. Formal advice is the stuff with the stamps, the signatures, the nice binding covers. A 100-page engineering report, for instance. But informal advice? That's the quick email, the water cooler chat, a rough sketch on a napkin. The fundamental skill the question designer is trying to measure here is whether you understand that the law frequently blurs the lines between these two. Just because you consider a quick chat or an email informal definitely doesn't mean the law is going to let you off the hook if you act carelessly while dispensing expert knowledge.
And that brings us to the absolute crucial point. Professional liability fundamentally hinges on the concept of foreseeability. The legal theory basically states that you owe a duty of care if it's reasonably foreseeable that a client, or honestly even a third party, might rely on your professional expertise. And that's regardless of whatever casual medium you use to share it.
Which brings us to Section 4, the correct answer explained.
Based on everything we just talked about regarding tort law and foreseeability, the correct answer is Option B. The decisive issue is whether reasonable reliance was foreseeable, notwithstanding the informal context.
Let's walk through the exact logical steps of why this is the right answer. First, the court is absolutely going to acknowledge the informal context of the email. They'll also acknowledge Step 2, your specific disclaimer. But here's the catch. They don't stop there. The ultimate legal test, Step 3, is assessing if, despite those things, it was still foreseeable that the client would reasonably rely on your words. Why? Well, because you're the expert. If an expert gives preliminary advice, and it's super obvious the client urgently needs direction to make a financial move, it might be entirely foreseeable that they're going to use that advice, disclaimer or not. Therefore, Step 4, foreseeability dictates liability. Option B cuts straight to the heart of that legal test. Let's jump to Section 5, avoiding conceptual traps.
Okay, let's look at why Option A is incorrect. Option A suggested that disclaimers automatically negate duties of care. I like to call this the disclaimer fallacy. Guys, this is a massive conceptual trap. So many professionals mistakenly believe that just slopping "not for Reliance" on an email is like some invincible magic shield. It's really not. Think about it. Writing "don't sue me" on a flawed structural design doesn't mean the building won't collapse, and it for sure doesn't mean you aren't responsible. While a disclaimer is absolutely a factor a court will consider, it does not automatically erase your professional duty of care, especially if the client's reliance was highly predictable.
Next up is option C, which suggested the decisive issue was whether emails constitute contractual representations. This is a trap specifically designed to confuse your legal categories. Remember, this question is rooted in tort law. Tort law bases your duty on relationships, proximity, and reliance. Contract law, on the other hand, bases duties on formal, negotiated, binding agreements where consideration is exchanged. The client's loss here stems from trusting your professional words in a tort context, not necessarily from a breach of a formal contract. Don't mix up your legal frameworks on exam day.
And finally, option D suggested the decisive issue was whether the advice was gratuitous. This trap relies on a super common misconception that if you aren't getting paid for the advice, you can't be sued for it. Wrong. Gratuitous advice, which just means advice given free of charge, can still absolutely attract liability if you are acting in your professional capacity and it is foreseeable that the person will rely on your expertise. Simply put, free advice is never truly free if you give it negligently.
Let's bring it all home with Section 6, Key Terms and Conclusion.
Let's rapidly review the precise terminology used in the question so you can fully master this legal vocabulary. A disclaimer is simply a formal statement intended to limit liability, but remember, not a magic shield. Reasonable reliance occurs when a sensible person trusts and actually acts upon your professional advice. Gratuitous means given free of charge, which we now know definitely does not eliminate your duty of care. And finally, foreseeable. Honestly, the most important word today, meaning a predictable or reasonably expected outcome.
And this brilliantly illustrates our ultimate educational conclusion for today's masterclass. As a professional, your responsibility is defined by the impact of your words and your expertise. The law looks at the reality of the relationship. How a client relies on your words matters vastly more than the casual medium you might have used to deliver them.
Which brings us to the end of our explainer. I want to leave you with this final thought. The very next time you sit at your desk, type out some preliminary thoughts, add a little disclaimer, and get ready to hit send on a quick and formal email, ask yourself, could someone reasonably act on this? Because if the answer is yes, you owe a duty of care. Thank you so much for joining me for this deep dive. Keep studying hard, and I'll see you in the next masterclass.